Court is in session. Be seated, please.
One of you wish to be seated?
Yes, Your Honor, please.
Let me first give repeat the instructions. I see we have 3 cameras here today. As has previously been made clear, you cannot photograph the jurors at all, not today, not at any time. There must be no electronic recording or transmission of any bench or sidebar conferences, any conferences between counsel or client, and any conferences between the court and a clerk or a court officer, and any conferences between counsel and client. You can only record during a proceeding, so when we have motions being heard or when the jurors are all in the box, you must stop when the jurors rise to leave, and there's no recording during any recess or when the trial is suspended. If you're not operating one of the 3 specifically authorized cameras, even if you're a member of the media, you cannot use your cell phone camera or any other kind of electronic device to take any photographs or to video anything except for attorneys. Anyone who's not a registered member of the media cannot have a cell phone camera or other electronic device in this courtroom, and any attorney who has a cell phone, tablet, or electronic device must have it turned off, not just silenced and put away. You cannot use it to photograph, record, or transmit any aspect of these proceedings or for any other purpose while you're inside the courtroom. And a reminder to the media to please make sure that your cell phones are in silent mode, and also that vibrate when silent has been turned off. And please, with respect to everybody, not just media, you must be silent at all times during proceedings. Anyone who wants to talk is free to get up and walk out of the courtroom and come back in, but you're not free to talk in the room. Mr. Sultan.
We do an open court? That's fine.
Unless there's some reason.
Your Honor, I appreciate the few extra minutes this morning. Thank
Sure.
you very much. Your Honor, I have 4 things to raise to the court. Number 1, Your Honor, last night I reviewed all the discovery that we received from the Commonwealth. We've received nothing from Mr. Aspinwall or regarding his opinions about anything since December. In his December written emails to the Commonwealth, he said, number 1, that what is depicted in the videos quote, appears to be a Glock, close quote, and he also based his opinion on the shape of the backstrap. Yesterday, Your Honor, he gave a different opinion. He said that he was reasonably certain it is a Glock, and he gave a number of different bases for his opinion other than the backstrap. Your Honor, the Commonwealth well knew that that's what Mr. Aspinwall was going to say yesterday. They did not provide that information in discovery, which I submit as a discovery violation, and to the extent that that it was inconsistent with what he said in December, and I submit that it is, it's a Brady violation. It's unfair. It surprised us. We basically had to go ahead and deal with him without having time to address this new and anticipated information. And based on those violations, number 1, Your Honor, I would move to strike his testimony. Number 2, Your Honor, I want the court to, I would like the Commonwealth to confirm my belief, which is that the photos that he was shown, that is the still photos that he was shown prior to his testimony yesterday, and about which he made what formed the basis of his opinion, were the photographs which had been altered by adding pixels, which were different than the photographs that he was shown yesterday. I don't want to inquire about that unless I know that that in fact is the case, but I assume it's the case, and if it is the case, then I do expect to question him on that. Third, Your Honor, as the court knows from our discussion yesterday, Mr. Aspinwall told Trooper Bates last year that he is, quote, by no means an expert in weapons identification. Your Honor, I feel I have a right to cross-examine him on that with respect to his level of expertise, since he has testified as an expert and has rendered an expert opinion I don't see any way, shape, or form, Your Honor, that might, as Mr. Bomberg pointed out yesterday, he made that statement originally when he was asked about the TMZ photograph. I don't see how, in any way, shape, or form, my bringing up that he said that, and that in fact is the case, would open the door to the TMZ photograph. But in an abundance of caution, I want to raise that with the court and make sure that in the court's mind, I would not be opening the door to that photograph by eliciting from him that he is not an expert in weapons identification, and that he made that statement to Trooper Bates. So that's my third thing. And finally, Your Honor, when the court ruled yesterday that Mr. Aspinwall could express an opinion, obviously a ruling that I strenuously disagree with, the court indicated or suggested that it would permit me to use photographs of replicas, photo array, and indeed exemplars. And I want to let the court know that I do intend to do that during this cross-examination. And in addition to photographs, Your Honor, I do intend to use a replica. And I want to let the court know that it's not a, I've had the chief court officer check it out this morning. It's not anything that would provide any danger to anybody, so that when I do use it, I just want the court to be alerted that I'm going to use it, and that it is something that has been checked out and is safe for everyone in the court. Thank you, Your Honor.
First, the discovery.
Your Honor, clearly the Commonwealth provided information about Mr. Aspinwall's observations. He described the uniqueness here. He described, we've previously had other hearings in which we discussed at some length uniqueness, not just of the backstrap, Your Honor. And the defendant was fully aware that he was basing his opinion on the unique characteristics of the Glock. He discussed that even yesterday, Your Honor. So it wasn't the...
Where was it disclosed that it was something other than the shape of the backstrap, and what?
In our hearing, Your Honor, you'll recall at least as to my memory, and I don't believe that that's the entire sum of it, but we had extended discussion about the tang of the firearm. And yesterday, what Mr. Aspinwall described was the unique characteristics of the Glock. That was done before he was ever shown any video, before the defendant's objection. We gave them notice that he was basing his opinion on his observations, his familiarity with the Glock. I think that the defendant, as exhibited yesterday in trying to prevent Mr. Aspinwall from rendering his opinion, knew full well what the opinion was based on. Mr. Aspinwall...
Just again, so specifically, you say the tang, was there any other thing that was...
Yesterday, Your Honor, the only other additional unique feature that he described as relates to the firearm was the trigger guard. He pointed out particular aspects of the firearm as he observed it in the video to orient us to the manner in which the firearm was being held, how it was being gripped. But as he described himself yesterday, his opinion, quite frankly, is based on the backstrap and the tang of the firearm where it meets the back of the gun. And that's important, Your Honor, quite frankly, because yesterday, you'll recall, the defendant in cross-examination of Mr. Aspinwall, and again, the defendant is asking you to strike his opinion. Of course, yesterday he starts cross-examining Mr. Aspinwall. He's asking him all about other 45s, not the basis of his opinion, and he's asking about guns that don't look anything like a Glock, that have different aspects to them, so he full well knew what it was. He's talking about a 1911 A1, which is manufactured not in a polymer frame, and that's the question he put to Mr. Aspinwall. So I don't know even the basis of him asking that. That's outside of his opinion. That particular firearm has a hammer to it. Couldn't be the same weapon. And so the defendant to suggest he didn't understand the significance of the description given by Mr. Aspinwall and then go into these other firearms that look completely different, Your Honor, I don't think that there's any basis to it. In his own filing, in response to our motion to an exemplar, says presumably he's going to describe it as a Glock, right? That's what he said. So for him yesterday in his prior filings and all of those other things to suggest that he did not know that that's what Mr. Aspinwall is going to say, Your Honor, that's not borne out by his activity prior to the opinion. And we went step by step. He described the unique characteristics, which there was no objection to. He described his observations in the video as the basis, no objection. He objected to the opinion. So he knew full well. As to point number 2, Your Honor, Mr. Aspinwall's initial contact, and the defendant is aware of this, was by viewing video taken from the DVR. And so he has done a number of things. He has viewed the video, he has viewed enlargements of the still photograph, and he's viewed the photographs that are in evidence. And he's testified his opinion is based on what's in the DVR and what's in those photographs. So
Photographs and evidence.
that's correct, Your Honor. And that's the basis of his opinion. As he's provided it to this court, I don't think he said anything else other than that. As to number 3, Your Honor, this...
did he look at, even though it was not the basis for his opinion,
He had, Your Honor.
has he looked at photographs where pixels were added?
He looked at he's looked at the photos about which the defendant complains.
Okay.
So that's true, Your Honor. But his opinion as he's delivered it to this jury is based on the items that he's described. As to this issue with Trooper Bates, Your Honor, and what's contained in Trooper Bates' report, Mr. Aspinwall was being asked to do something different. That gun is clearly a Glock. The question wasn't whether it was a Glock. He was being asked to identify with specificity the model and the generation of the gun. That, he felt, on the basis of that photo, he was incapable of doing. That is different than what he has placed in front of this jury in regards to the evidence that's in front of this jury. I'm going to suggest to the court that if the defendant inquires about that, since it's different and it's based on something that's different, the jury should understand what he was asked and what his response was in context. And so the defendant is asking the court essentially to be able to pull out of context a statement that was made, contextualize it, and then use it to suggest something completely different to the jury. If the defendant chooses to cross-examine Mr. Aspinwall about that, I think that the Commonwealth would be entitled, Your Honor, to put his statement into the full context.
May I respond, Mr. Bomber?
I don't think I've gotten to the final point here. Oh. As to a replica, I haven't seen the replica. You'll recall, Your Honor, we've asked the defendant for any items he intends to introduce into evidence. I'd like an opportunity to take a look at it.
I don't intend to introduce
I
it.
assume this is not intended to be introduced into evidence?
That's correct, Your Honor.
Well, he's going to make some evidentiary use of it, Your Honor. I think we should at least...
I just wanted to clarify. I assume this
No,
is
I
chalk,
can see that.
and I will have him show you the chalk before we
Thank you.
sure it's in.
Thank you.
Your Honor, if I may respond briefly. With respect to the bases for Mr. Aspinwall's opinion, we heard yesterday about the squared-off portion of the slide and the trigger guard area, and indeed he traced the trigger guard area on the screen. That is the first I've ever heard of either of those two bases for any opinion of Mr. Aspinwall. Secondly, Your Honor, Mr. Rankin went to print it, but I am quite confident that in our filing I would have conformed to what they represented was his opinion, which is that it appears to be a Glock, but we're getting that, Your Honor. With respect to the issue of what Mr. Aspinwall relied upon, in his email to the Commonwealth in December, he said, and I quote, "I have looked at the video and corresponding stills," close quote. So it's clear that he's basing his opinion on not just the video, but also the stills, which are the enhanced stills. Third, Your Honor, with respect to this issue about him being an weapons identification expert, frankly, Your Honor, if he is not capable of being a weapons identification expert with respect to that excluded photograph, where it is quite obvious what is in the photograph, if he can't identify that, then it is ludicrous to think he would be an expert to identify a blob in a grainy photograph or a grainy video. And, Your Honor, for me to be foreclosed from establishing the limitations, the admitted limitations of his expertise without opening the door to that unfairly prejudicial and excluded photograph would be, I think, a constitutional violation of my right to confrontation. And I asked that I be permitted to do that without opening the door. Thank you, Your Honor.
And just as regards that particular email, Your Honor, in speaking with Mr. Reset, those were emails in the native format similar to this. He, in the interim, also has seen the other ones that we intended to use, but which we forewent. So he has looked at the other larger blow-ups, Your Honor, but that's not the basis of his opinion before this jury.
With respect to the extent he was making a conclusion as to whether, in his opinion, it was a Glock or not, based on the squared-off portion of the slide and the trigger guide area, what disclosure was there that those two things would be the basis for his opinion, as opposed to the shape of the backstrap and the tank?
The trigger guard, Your Honor, is all he did yesterday, as I remember his testimony, was identify it in the photo with the hand behind. He was orienting people to the orientation of the firearm, how it was being held. That's where he described the trigger guard. In regards to the squared-off portion in the back, all he has done, Your Honor, is traced along the back strap to the tang and then up. And that's relevant because, as you remember, Your Honor, both from his testimony about the uniqueness and the discussion that we had about the tang, it ends at the back of the slide, unlike other firearms. And that's what he is delineating there.
Your Honor, I just want to correct
At that squared-off portion, what he described, Your Honor, is how the backstrap curves, it goes to the tang, and it terminates right there in the area of the squared-off portion of the back of the slide.
And the difference between expressing an opinion that it's Glock to a reasonable degree of certainty and that it appears to be a Glock?
The formulation, Your Honor, is reasonable degree of certainty. That's I don't see that that's an issue.
I just want to correct, Your Honor, Mr. Bomber's misstatement about what's in our motion. This is our motion to preclude admission. Page 2, specifically, you wrote, quote, "Mr. Aspinwall will presumably opine that the object in Hernandez's hand," and then quoting him, "appears to be a Glock pistol," close quote, based, again quoting him, "on the curve of the backstrap," close quote, and we attach the correspondence between Mr. Aspinwall and Mr. Reset as an exhibit to that pleading.
Right. So they full well knew he was going to express the opinion that he believed it to be a Glock. The fact that he has done that in conformance with the formulation that's required to a reasonable degree of certainty should come as no surprise, because they knew he was going to express an opinion and that that was the formulation it would have to be in.
Thank you. The motion to strike is denied. With respect to the still photos that he's viewed, the witness has in court expressed his opinion only on the exhibits that are in evidence, and on exhibits in evidence. The fact that he may have looked at other things doesn't make his opinion inadmissible when he did not rely on it in court. To the extent you are introducing into evidence or introducing that he looked at things other than his opinion, it may certainly open the door to what those were. And so that's the decision you have to make. But the witness has expressed his opinion only on what is in court. The court never made a decision as to whether those other pictures would be admissible because the Commonwealth chose not to try to put them into evidence or have the opinion based on them. With respect to the statement that he wasn't an expert in weapons identification, I'm not going to, you can certainly ask him about that statement, and to the extent that that statement was in the context of being asked to specify the model and generation of a particular Glock, that he was not unable to say it was a Glock, I would allow that to come out in cross without any reference to the fact that the photo he was looking at was a photo of Mr. Hernandez or purporting to hold a Glock. But he could certainly say, I was shown a picture, that statement was made in the context of my being shown a picture of what I knew to be a Glock, or what in my opinion was a Glock, and I was expressing the view that I couldn't tell what particular model Glock that was, or what generation Glock that was, and to the extent he understood that picture was taken in 5 years ago or 7 years ago, he would be able to so indicate, to the extent he was not familiar with model Glocks at that point of time as he may be at the current time. So you can ask, it will open the door to some extent to the fact that there was a photo he was shown. The jury may or may not draw some inference that that photo, if he was shown that photo, had something to do with this case. But I agree with the defendant that it would not open the door to introducing that photo or to indicating that that photo was a photo of Mr. Hernandez holding a Glock at some period of time.
Your Honor, I think that's very fair. I guess I would just ask that the witness be instructed, in the event that I do go into that, that he not essentially disclose the information the court has ruled is not being let in.
I'm sorry, the Commonwealth to speak to you.
Right.
I'm not going to instruct him.
Right. And that it will take another 5 minutes before I bring the jury down, so if you want to show the replica or any photographs you have, or the replica or whatever you intend to try to use as a chalk, so if there is any objection, I get it now or not. If you could just show them the replica.
Sure, I'll do that.
And we'll come back out in, let's say, 5 minutes.
Thank you.
And that gives you time to instruct the witness with respect to the photograph.
Your Honor, and I would just, well, I guess I'm concerned about the witness being, and I'm not casting any aspersions on my colleagues at all, but I don't, if I'm going to show them what I want to use, I don't want them sharing that information with the witness.
I'm not going to speak to him about it. I'm going to instruct him as the court's told me to instruct him.
So I guess my request is that that occur first, and that then I show them what I'm going to show them.
Fine.
That's fine. As was indicated, sidebar, there's conversation with witnesses during the cross, but this is a very limited, and it's for this limited purpose that Commonwealth should instruct the witness that to the extent he's asked about that statement and any explanation for the statement, he may not indicate the nature of the photograph that he saw in terms of that it involved Mr. Hernandez. So 5 minutes, I'll come back out and we'll bring the jury in.
Would all rise?